Hello, my name is Clay Landa, and I, along with my colleague today, Colin McCarthy, we're going to be presenting a webinar for you all on government enforcement actions. Just to give you kind of a brief overview. There's obviously a lot of different government enforcement actions we could speak about in the healthcare space, so we are going to be trying to kind of provide a little bit of a focus review today. And that'll start with me going over the Office of Inspector General, or the OIG, Audit and Enforcement Authority, just a little bit of general background for what they do, how they can do it, and how they can enforce their authority. I'm then going to go into a few recent enforcement actions that are either supported by or conducted by the OIG, and the difference there is that the OIG has its own enforcement authority and ability to issue CMPs and exclude providers, but they very often work in a support role and in concert with other government agencies as well for criminal and civil investigations and prosecutions, and they also work with the state Medicaid fraud control units and Attorney General's offices. So I'll touch on a few state enforcement actions as well. I'll then turn it over to Colin, who will discuss some CMS enforcement actions. So to start with, just generally, what is the OIG's authority? There's actually an Inspector General Act, a federal act that grants the OIG authority to conduct and supervise audits and investigations relating to the Health and Human Services programs, which is primarily Medicare and Medicaid, but it also could include TRICARE or other federal health care programs. Under the Act, the OIG is granted access to all records, reports, audits, reviews, documents, and papers that could be applicable to that federal health care program. Now, the HHS OIG is actually the largest Inspector General's office in the federal government, and a majority of the OIG's resources goes towards oversight of the Medicare and Medicaid programs. And you can see just by these statutes here, but with what they can review and what they're allowed to request, their investigatory authority is very broad. They have statutory authority to request a vast amount of records, data, and information pertaining to a Medicare and Medicaid provider's participation in federal health care programs. The OIG is actually divided into 6 component offices. The Office of Audit Services and the Office of Investigations play the most pertinent part in what we're talking about today when we talk about enforcement actions. And it's either as I said, their own enforcement actions or assisting the Department of Justice and the various U.S. attorneys' offices in bringing criminal and civil actions against providers. The Office of Audit Services does conduct independent audits of HHS programs and providers and suppliers. Very often, those audits will turn into a recommended overpayment if they found one for a provider, but the OAS doesn't actually seek that overpayment themselves. In that case, they very often issue a report, and then they'll actually turn their findings over to the Medicare Administrative Contractor, or MAC, who may actually issue an overpayment demand. Now, the Office of Investigations is much more specific to enforcement, and they conduct criminal and civil and administrative investigations of fraud and misconduct related to HHS programs. And as I said, that criminal and civil enforcement may lead to action by DOJ or the U.S. Attorney's offices, or they can seek their own civil monetary penalties against providers and exclude providers from participation in federal health care programs. The Office of Investigation also operates a hotline that allows for the reporting of suspected fraud, waste, and abuse, and it coordinates with the Department of Justice and state law enforcement authorities to leverage all resources to fight fraud. Many of you may know that the CMP authority and the regulations in 42 CFR Part 1003 were updated a few years ago in 2016. But the actual reasons for which the OIG can seek CMPs have been pretty consistent, and you can see the list here. It's pretty much the well-known issues that we face as healthcare attorneys today, or healthcare providers may face if they're concerned about having a CMP imposed against them. They can have CMPs imposed for false claims, claims against ownership, employment, or ordering of services by an excluded provider, improper inducements, and this is where we talk about improper referrals under the anti-kickback statute, if they've submitted false enrollment information, if they've ordered or allowed for the provision of medically unnecessary services or supplies. They can also have a CMP imposed against them about a knowing retention of an identified overpayment, or if they fail to grant access to the OIG when they've requested records. Also, a knowing Stark violations and EMTALA violations. And so these will be some of the government enforcement actions I'll talk about today. As I said, there were changes in 2016 to the CMP authority, and the primary change was that they actually increased the CMPs that could be issued, and they did that to adjust for inflation as well. I don't have to go through this list that you can see here today, but many of the penalties, or all of the penalties, have gone up. I've just listed a few here, the most well-known ones here for you, but there is a long table that's actually in the regulation showing how each of the potential claims has gone up for a CMP that can be sought. Also in 2015, the OIG actually initiated a new litigation team, and that team was solely focusing on issuing CMPs and excluding providers for potential Medicare fraud, Medicaid fraud. At its, when it was fully developed, it was supposed to have 10 dedicated attorneys focused only on increased enforcement, and they even noted that their initial focus was going to be on kickback-related issues and specifically with particular physicians. So I'll turn right into some actual healthcare actions that have come out recently by the OIG, either them seeking them themselves or working in concert with other government actions. Many of you have probably seen this, that on June 29, 2018, Attorney General Jeff Sessions announced the largest healthcare fraud enforcement action in the history of HHS. They levied charges against 601 defendants involved in fraudulent practices involving more than $2 billion in claims. This was actually a joint action undertaken by DOJ, the FBI, DEA, OIG, IRS, and state Medicaid fraud control units, or MIFCUs, and it was coordinated by the Criminal Division of the Fraud Section's Healthcare Fraud Unit. Key amongst these charges was another area that I'll talk about in a number of cases coming up, that the opioid epidemic that has been sweeping the nation. The opioid epidemic has been a criminal issue as far as dispensing controlled substances that should not be dispensed, or if you have a physician that's actually issuing prescriptions for medically unnecessary services. But this is now turned under the OIG and the MIFCUs, as well as the Attorney General's office. They've also looked at it from a healthcare fraud perspective, to say essentially that if a physician is issuing a prescription for an opioid when there wasn't a medically necessary reason and it was paid for by a federal healthcare program, we now also have a federal healthcare fraud charge. So you can see that 76 doctors were involved in these fraudulent prescriptions and dispensing of opioids. Some specifics of these cases also included illegal recruiting of patients, and kickbacks and fraud, also related to widespread urine testing for substance abuse treatment services. That alone was supposed to have accounted for $106 million in alleged fraud. There were also cases where there was attorney and marketing efforts that were offered kickbacks and incentives, including even prostitutes to pediatrists for prescriptions and pre-printed prescriptions given to people. They alleged that that amounted to $250 million in fraud. The fraudulent number of prescriptions for bulk orders of hydrocodone and oxycodone involved nearly $291 million in alleged fraud as well. So I want to turn to some specific cases outside of that large case for the 601 defendants that were charged in June. And as I said, I'm going to be focusing a little bit on a number of cases that have come up that are addressed by the opioid epidemic and all of the government's actions to try and cease or to try and tamp down on the opioid epidemic. A Philadelphia pain management clinic was actually charged after an investigation by the DEA, OIG, Philadelphia Police Department, and the U.S. Attorney in running essentially what they determined was a pill mill for oxycodone and Xanax. A hired physician by that pain management clinic wrote prescriptions for those drugs for up to $260 to $360 a pop without performing any medical exams. The physician also gave the owner of the clinic pre-signed blank prescriptions to be issued in her name. I also want to note here, when we're talking about the opioid epidemic and physician involvement in healthcare fraud, a number of states have updated their regulations and guidance to indicate what the standard of care should be for pain management, and especially if you're having a long course of treatment with opioids or narcotics. And those are essential for those physicians to be following those types of guidelines to ensure they're not only dispensing controlled substances for a legitimate purpose, but that also they could not be wrapped up in a healthcare fraud investigation if they were actually dispensing them when the person was undergoing a pain management practice that is meeting the standard of care. Another similar case involved an Alabama pain management doctor who received a 5-year sentence in order to pay $15 million in restitution. Now, this former neurologist, as I said, was sentenced to 5 years in prison related specifically to his pain management practices. There were a number of charges involved, including healthcare fraud, making false statements, lying to federal agents, and unlawfully distributing Schedule II controlled substances. Some of the practices here were particularly egregious. This pain management doctor actually administered unnecessary injections and attempted to inject patients in places where they were not experiencing or complaining of any pain in order to ramp up his federal reimbursement. He also told patients that they had to receive spinal procedures and diagnostic testing in order to receive prescriptions for controlled substances. Again, the The OIG noted specifically that he caused his patients pain by requiring them to undergo these procedures rather than alleviating their pain. He also used improper medical techniques and equipment in performing the procedures. An interesting note about this case was that he also failed to monitor his patients' vital signs during and after procedures, which actually put them at risk for complications. And he actually discriminated against Alabama Medicaid patients in services rendered. And this included he singled out Alabama Medicaid patients to receive spinal injections in regular exam rooms as opposed to fluoroscopic procedure rooms without imaging guidance if he was behind schedule so he could maximize his billings. In another case, we had a Fort Lauderdale doctor, Dr. Andres Mencia, who was convicted for performing sham consultations with cash payments for the purpose of prescribing opioids and narcotics. In this case, again, we had an issue of pre-signed prescriptions to issue to known cash-paying patients in this case. Once the investigation began, they actually found that patients' records were even labeled, specifically with a notation for CS to note that they were cash-paying patients so that they could be handed these prescriptions and increase the revenue for Dr. Mencia. Another case involved the CEO of a pain management clinic and the physicians he hired to operate that clinic in a fraud and kickback scheme related to pain management. This was in Michigan and Ohio, and again involved a fraudulent scheme to prescribe opioids and provide injections that were medically unnecessary. In total in this case, there were over 4.2 million doses of medically unnecessary controlled substances. The CEO also owned diagnostic laboratories and caused the physicians to order medically unnecessary urine drug testing, which, as you can see, totaled $6.9 million in improper claims. In this case, some of the specifics were that the CEO paid the physicians based purely on the number of injections that they issued, regardless of medical necessity documentation. So we had kind of a pure pay-for-referral system going on here. Medicare even did an initial look at these claims when they saw how many were coming in and determined that 100% of the claims were not medically necessary. So even after Medicare suspended the billing privileges based on this first review, the CEO and the physicians conspired to create new shell companies that enrolled them in Medicare and kept up the same practices to bill for unnecessary medical treatment. Medical review also of urine tests found that 95% of the claims were not eligible for payment. Another recent case that really caught a lot of people's attention was the Pfizer settlement. Pfizer entered into a settlement for $23.85 million and had to enter into a corporate integrity agreement in a case involving kickback allegations. The Pfizer essentially funneled money to a separate foundation, a nonprofit foundation, to pay the copays of individuals that were taking 3 Pfizer drugs. Pfizer had recently actually raised the price of one of these drugs by 40%, and it knew patients might not be able to afford that price. Pfizer then worked with the foundation to create a fund and support it financially. They then referred patients to the fund. For the next 9 months, these patients referred by Pfizer actually amounted to all of the beneficiaries whose copayments were paid by the fund. The fund was supposed to be set up to help all types of patients, but they were only helping Pfizer patients pay off their copays. Pfizer also allegedly used a third-party specialty pharmacy to be paid by the foundation for the drugs, and that way they could keep track to ensure that all of their copays were being paid, and they could keep a closed system to know that their patients were actually receiving the drugs and keep the money flowing to Pfizer. Pfizer entered into a corporate integrity agreement with the OIG that will span for 5 years. There they were required to implement measures designed to ensure that arrangements and interactions with third-party patient assistance programs like the foundation are compliant with the law. In addition, the CIA requires that they actually have reviews by an independent review organization. It has compliance-related certifications that have to be completed from company executive and board members, and they had to implement a risk assessment and mitigation process. Another area that's seen some increased enforcement is dealing with behavioral health and potential Medicare and Medicaid fraud in the behavioral health world. This effort has been undertaken specifically by the OIG and state MIFQs as well as states attorneys general. In this case, we had a Connecticut psychologist who billed for services that were not provided and also billed for family therapy sessions for multiple family members when really it should have been billed to only one family member. So this case for just this one psychologist was relatively low at $126,000, but it does show that behavioral health is another area where the state MIFQs and the OIG are interested in increasing enforcement. This was an interesting case where a St. Louis doctor was actually found guilty or pled guilty to obstructing an investigation. The guilty plea was related to false entries made in the medical records for face-to-face visits. The FBI essentially alleged that these falsified entries in the medical record, as they took place, they were actually an effort to impede, obstruct, and influence the investigation. The doctor in this case actually used template forms that falsely recited patient symptoms and histories, and even sometimes recorded vital signs that did not change between patients' visits. The doctor was often out of state and the country when these face-to-face visits were supposed to be taking place. And this stresses the importance of being careful of keeping your accurate and timely records and the potential warning signs of using template forms. A number of physicians and providers will often want to use template forms to try and increase speed and efficiency of filling out those forms. When you're doing so, you do have to be careful that you're actually accurately capturing the information of each patient visit. The next case I'd like to discuss is dealing with a nursing home CEO, and he was the CEO of American Senior Communities, who recently pled guilty and was sentenced to 9.5 years in prison for healthcare fraud and kickback violations. Now, American Senior Communities was, I believe it still is, Indiana's largest nursing home chain, and it managed approximately 70 facilities. Burkhardt, as the CEO of that facility, and others made deals with vendors for kickbacks to obtain the business of this largest nursing home chain in Indiana. Burkhardt actually had vendors inflate their bills that were going to be paid for by Health and Hospital. Health and Hospital is a public-private partnership that was managing a number of these facilities together with American Senior Communities. And they would pay these inflated bills, and the excess amount would go back to Burkhardt and his associates. He also created shell companies that inflated the vendors' bills, submitted them to ASC as if the shell company was the real vendor. He also caused the shell companies and vendors to submit bills for services that were never rendered. As you can see, this was a particularly egregious case. I believe the notations of the investigation actually found that he made almost $1 million salary, but the OIG said his motive was pure greed. He was caught on tape even telling an informant in reference to one of his schemes that netted him over $600,000 a year. I ain't giving that up. It doesn't sound like much money, but it's money. This case may have an important factor for many lawyers if they're attending today to consider if they ever deal with claims and settlements that are paid for by Medicare in an injury case. In this case, the Philadelphia personal injury law firm of Rosenbaum and Associates, its principal, Jeffrey Rosenbaum, entered into a settlement to repay conditional payments that are made under the Medicare secondary payer regulations, and he had to start a compliance program. Now, under the Medicare secondary payer provisions of the Social Security Act, Medicare is authorized to issue conditional payments for items or services that are provided in the case of an injury or an accident. Very often when a settlement is then reached that will cover the cost of those services, Medicare regulations require the person who received the settlement to return it within 60 days, even if this is the attorney and the actual injured person has already received the settlement. So in this case, the attorney had not paid back those conditional payments. Rosenbaum also acknowledged that any future failure to submit timely repayments could constitute a false claim by retaining an identified overpayment in this case. Another case that was interesting that recently popped up was a New Jersey pediatrician, where the OIG entered into a settlement with the pediatrician involving allegations of false claims. The pediatrician actually billed for services under her NPI when she did not provide the services or personally supervise the services. The pediatrician also billed for services under her NPI because she had practitioners in her office that weren't credentialed with Medicaid, and therefore she couldn't submit the bills and receive reimbursement. This case illustrates something we often see in billing matters, that physicians bill under a physician's NPI to receive higher reimbursement, but quite often if they don't actually perform the service, and it's like a nurse practitioner or a physician assistant, they should receive a lower reimbursement rate. Or they're improperly billing thinking that they're billing under the Incident to billing rate, but they actually haven't provided an Incident to service. There was also a recent settlement, or a number of settlements, and I provided one today just as an illustrative example of Oklahoma ambulance settlement for $566,000. In this case, the ambulance company allegedly uploaded claims by billing for non-emergency transport at the emergency rate. During the course of the investigation, the company also discovered and actually did disclose claims for emergency ambulance transport that were not medically reasonable or necessary. The company also disclosed documentation meant to support the transport was not consistent with the patient's actual conditions for some claims. This case also involved the OIG's Consolidated Data Analysis Center, which uses sophisticated data analytics to track down potential improper payments. Really, this just illustrates that providers should be aware that if their billing could be viewed as outside the norm, it can likely be picked up by such a data analysis. A Michigan rehab center also recently settled a case dealing with kickback and start violations. In Essexville, Michigan, this rehab facility entered into the settlement agreement where the laboratory actually provided point-of-care drug testing cups to the facility, and they said that this essentially amounted to improper remuneration and prohibited referrals. The OIG alleged that the provision of these point-of-care test cups created a financial relationship, and that the rehab facility caused the laboratory to submit claims for designated healthcare services under START. There was also a very similar case recently in Alabama, again, with the free provision of point-of-care testing cups. And this shows that any providers that are involved in this world of healthcare need to be wary of having any laboratory provide free or discounted services. Now I'm going to turn to a number of EMTALA cases just to show what the recent enforcement actions have been in EMTALA. A Tennessee hospital recently settled for $25,000. And here the OIG alleged that a patient presented to the hospital complaining of blurred vision and dizziness. An ED nurse directed the patient to a local eye doctor. So the OIG alleged that they never performed an appropriate medical screening exam, MSE, and they never provided appropriate stabilizing treatment for an emergency medical condition. Now this also illustrates the point that you want to have proper people actually performing your MSE, the right designated practitioner. And very often this is not going to be a nurse. You might need someone as high as a physician, and normally it is a physician, to be saying you're doing a proper medical screening exam. An Iowa hospital also recently settled an EMTALA claim for $90,000. And in this case, a patient presented to the ED complaining of shortness of breath, chest pain, and diaphoresis. The ED physician did perform a general screening of the patient and contacted the on-call cardiologist, so it seems that things were progressing as the way they should. But the patient worsened and was intubated by the ED physician. Again, on advice of the on-call cardiologist, he began transcutaneous pacing, but the ED physician never actually requested that the cardiologist come on site and perform his own examination. The ED physician transferred the patient for placement of a pacemaker, which was performed by the receiving hospital, but unfortunately the patient expired or passed away soon after. The patient was transferred nearly 3 hours after presenting to the ED. In this case, the OIG alleged that a proper MSE, or medical screening exam, was not performed and proper stabilizing treatment was not provided. And the primary reason was that the ED physician did not request that the on-call cardiologist come on site. The cardiologist never did appear, and the cardiologist could have provided the pacemaker himself. A North Carolina hospital also recently settled EMTALA allegations for $200,000, and this involved a number of patients, up to 4 patients. In one instance, the ED physician ordered labs and fluids, but discharged the patient after 10 hours, only to have him return 6 hours later. A separate ED physician at the hospital actually diagnosed a traumatic subdural hemorrhage and transferred the patient to another hospital for brain surgery. Again, the patient subsequently died at the receiving hospital after several weeks, but the EMTALA violation was that the first physician did not perform a medical screening exam. In the second case, a male presented with lethargy, overdose, several medications, depression, and expressed suicidal ideation. While diagnostic tests were ordered, the ED physician never ordered a psych evaluation. After discharge, the patient unfortunately committed suicide. And this stresses the importance that psychiatric conditions are considered emergency medical conditions under EMTALA. Therefore, you have to order the right services, right exam, to ensure that you're providing a medical screening exam. Diagnostic tests are not sufficient in this type of case. You do need to consult with a psychiatrist or use the resources of the hospital to perform an appropriate psych evaluation. There were two additional patient cases involved in this EMTALA case that involved a failure to have an effective transfer. One was a patient who presented with altered mental status after being found with an empty medication bottle. Tests actually showed that there were brain hemorrhages and a possible aneurysm, so the ED physician determined that a transfer of over 122 miles away for surgery outweighed the risks of that transfer. However, that transfer didn't take place for 6 hours, and there was never another assessment of the risk prior to transfer during that 6-hour interval. In the second case, it was a very similar case, but a pregnant patient who arrived. She waited for 2 hours for her transfer while she continued having contractions and was in labor, and no subsequent assessment was done prior to her transfer. Now I'm going to talk a little bit about excluded providers. Just from general background, as I said at the beginning, you can receive a CMP for actually employing or contracting with an excluded provider, and that is a person who's been excluded by the OIG from participation in all federal health care programs. You can also receive a CMP if you have an owner of a provider that's enrolled in Medicare that has been excluded by the OIG. The OIG's list of excluded individuals and entities is where they put all of the names of entities and individuals they've excluded from participation, and they stress that people should check that list at least once a month and upon hire to ensure that they are not employing or contracting with an excluded provider. Not only could you receive a CMP, but any services that were ordered, rendered, or that were payable, either directly or indirectly, by federal health care programs are considered an overpayment if they are related to an excluded provider. In this case, we had a home health agency that employed a nurse that was on the OIG's LEIE. The OIG's investigation revealed that the nurse did provide home health nursing services. Now, in this case, it can be sometimes hard to quantify the amount that would be the overpayment that the person has to pay back, because home health is paid under an episode of care, where you receive essentially one bulk payment for an entire episode of care. In this case, though, there is guidance from the OIG in their self-disclosure protocol that says if it's not a specific service that's ordered by a person, for example, a physician ordering a service or a test, or a physician performing a surgery, then you would actually take that individual, such as the nurse, total salary, which is all of her cost of employment, which is her salary, which is employee paid taxes and any benefits, and multiply that by the federal payer mix to arrive at the overpayment that should be associated with her services. And very often as well, the OIG will also issue a 1.5-time multiplier as a penalty for contracting with that excluded provider. This case also illustrates another point that has come up in the past that I've seen, whether or not what role the nurse played. Because if she was the initial nurse assessment that then allowed all the episode of care to follow after that in home health, the entire episode of care could be at risk as an overpayment rather than just the nurse actually attending to the patient for one home health service in the home. The Alameda Health System also recently reached a settlement with the OIG for over $257,000. And this case illustrates the point that it's not just direct care providers that have to be worried about being on the LEIE. Hence, you shouldn't just check your licensed practitioners, your physicians, your nurses, or anyone else who's a licensed medical professional, but management staff, HR staff, and administrative staff also cannot be providing services to Medicare beneficiaries if they are on the LEIE. This case involved an employment of an eligibility clerk that was excluded by the OIG. Again, the OIG noted the clerk provided items or services that were paid for by federal health care programs, even though the clerk wasn't actually providing direct medical care. Again, they didn't specify how the overpayment was calculated. For example, whether all individual claims, beneficiaries that the clerk worked on were considered overpayments. As I said earlier, it's more likely that it was based on the total cost of employment of that eligibility clerk. I've just listed a few here for you on one page and without much detail here, but these also stress that there are settlements involving management and administrative staff as well, such as another Ohio home health agency that employed an excluded individual who was just a scheduling and staffing coordinator. But again, the total cost of employment of that coordinator multiplied by the payer mix arrived at the overpayment amount with a multiplier for a penalty. This was a very interesting case as far as an exclusion angle is concerned, regarding a New Jersey physician who agreed to a further voluntary exclusion based on his prior exclusion. So here we had a New Jersey physician who was excluded from New Jersey Medicaid in 2012. Subsequently, the OIG in 2014 also excluded him from participation in all federal health care programs. Now, at the time of his Medicaid exclusion, he actually did transfer the ownership of his business, somehow thinking that that was going to make his continued work for the practice allowable under federal rules. However, the physician did continue to provide administrative and management services to the practice. So in conjunction with settling his False Claims Act liability for other services he rendered, the physician had to agree to a further voluntary exclusion of 5 years. This case underscores that you are not just excluded in the role that you were in, you were excluded as a licensed medical professional. You can't provide any services or items to a Medicare beneficiary that may be paid directly or indirectly. So you can't change roles and get out from underneath your exclusion. I'm going to turn just briefly to a few state enforcement actions. The North Carolina Attorney General recently announced a settlement with Rotech, which is a durable medical equipment or DME supplier, for nearly $10 million. Rotech allegedly automatically billed Medicare and Medicaid for portable oxygen, regardless of whether the patients used it or needed it, and didn't obtain a proof of delivery. Now, under DME requirements, the DME supplier must obtain a physician order and a certificate of medical necessity in most cases prior to dispensing the DME. The DME supplier must also obtain a proof of delivery, and all of this must be in their records to support the billing for the services. The AG in this case alleged that Rotech continued with their practices even though they knew it was not meeting these eligibility requirements. This case was also joined by 22 states and the federal government, and a team was actually appointed by the National Association of Medicaid Fraud Control Units to participate in the investigation and participate in the settlement negotiations with Rotech. The New York Attorney General also recently obtained a guilty plea from a pharmacy involving a $1.5 million Medicaid fraud scheme. Here it was the owner of the pharmacy who was alleged to have violated state fraud and kickback laws, and he received a 6-month sentence, 5 years probation, on top of the $1.5 million payment. The pharmacy owner here paid an employee of a hospital kickbacks to direct expensive cancer prescriptions to the pharmacy. The kickbacks here included a monthly cash referral fee if the number of referrals was met, and also provided the employee with other items of value, including tickets to sporting events, an iPad, and free meals. This case involved state False Claims Act violations based upon the investigation, discovering that the pharmacy also did not order enough medications from drug wholesalers to actually fill the number of prescriptions they said they were getting. So it's an interesting angle on the evidence that was used to have a False Claims Act violation. The final case I'll touch on briefly was the Nevada Attorney General who obtained a conviction against a Medicaid behavioral health provider for over $1 million. This is an interesting case because of the actual charge here. The Nevada AG obtained a conviction on a gross misdemeanor charge of intentional failure to maintain adequate records and placed the provider on probation for 3 years in order to pay restitution of over $1 million. The state MIFCU, or Medicaid Fraud Control Unit, investigated after receiving an allegation that the provider had not provided services as billed to Medicaid. The investigation showed that the provider intentionally failed to maintain accurate documentation to support the services billed. As I've stressed throughout this presentation, this also notes the importance of keeping accurate and timely records. You should not go back and amend your records in such a way that they would look like you're trying to falsify the records if you need to put in additional notes in your record. I'll now turn it over to Colin, who will talk about some CMS enforcement actions.
Thanks, Clay. Clay just provided a great overview of some recent OIG and state enforcement actions. In those cases, the government is enforcing the civil monetary penalties law, or the False Claims Act, leading in most cases to a monetary settlement, sometimes with an exclusion. I'm going to switch gears and talk about another way the government brings enforcement actions against healthcare providers, more from an administrative standpoint. The Centers for Medicare and Medicaid Services, or CMS, has numerous tools in its toolkit to combat fraud, waste, and abuse in the Medicare and Medicaid program. I'm going to focus on Medicare program for purposes of this presentation, but different state Medicaid agencies have similar tools regarding audits and provider enrollment to enforce actions against healthcare providers. These administrative enforcement actions from CMS can significantly hinder healthcare providers' ability to participate in or receive reimbursement from Medicare and Medicaid. I'll focus on actually 3 topics today, the first being claims audits. These are typically done by ACT, Medicare Administrative Contractor, ZPIC or UPIC, as they're now being transitioned to, and other types of auditors who are contracted to audit claims on behalf of the Medicare program. Second, I'll talk about provider enrollment enforcement. CMS has the authority to either deny a provider's potential enrollment in the Medicare program or revoke current Medicare billing privileges, which can be fatal to a healthcare provider's business. And last, I'll talk about payment suspension. This is authority CMS has to suspend Medicare providers' payments in certain situations. First, we'll talk about claims audits. On the slide is a list of some of the various auditors who audit Medicare providers' claims. These can come in many forms, and these different auditors serve different roles within the Medicare program integrity structure. The most common audits that we see, aside from investigations from the DOJ and OIG are audits from the MAC, the contractor that processes the provider's claims, and the ZPIC or UPIC. ZPIC is a Zone Program Integrity Contractor. UPIC, the Unified Program Integrity Contractor, which is the current iteration of the ZPIC. The ZPICs and UPICs are focused on potential fraud within the program and use data mining to identify providers as targets for investigations and audits. These claims audits typically involve one of these CMS auditors requesting records to support services that were billed to Medicare, reviewing those records against program requirements like regulations, manual instructions, coverage determination, and determining whether or not the provider's records support the services that were billed. As you can expect, in many cases, the auditors do find overpayments, and that triggers appeal rights for providers. The overpayments found can range from very small, from a few hundred or thousands of dollars, to enormous overpayments of millions of dollars, especially when the auditor is using extrapolation to review a small sample of claims, but extrapolate the overpayment findings to a broader universe of claims over several years. Providers can appeal overpayment findings from any of these auditors. The appeals process, which we've outlined in a previous presentation, is very long, and there's currently a backlog at one stage of the process, with the administrative law judge stage, that's currently about 3 to 4 years. So CMS, as part of the audit and appeal process, can end up recouping money that was paid to the provider based on overpayment findings from one of these auditors, and potentially hold on to it for years before the provider has a chance to go through the whole appeals process and potentially win on their appeal. There are several types of claims audits, as noted on this slide. They can come in the form of a prepayment or post-payment audit. The prepayment audits typically come after the submission of a claim to the Medicare contractor before payment is made. This can hold up payments for several months while the prepayment audit goes on before the contractor makes a determination as to whether or not to pay the claim. Oftentimes, claims audits are done on a post-payment basis, and auditors can reopen claims generally for up to 4 years prior to the audit. It can expose a large number of claims that have already been paid to potential risk of recoupment. The audit can be a complex review, which involves reviewing actual documentation, or a non-complex review, which is more of an automated review of coding to find potential coding errors based on things like the National Correct Coding Initiative edits or the medically unlikely edits. This slide outlines the prepayment review process. I won't go through all the details in the flowchart, but it's important to note that some MACs are providing checklists of documentation to providers to provide certain information on certain services that are subject to prepayment review. It's definitely best practice to follow those checklists and ensure that all supporting documentation for a claim, even if it's not on the MAC's checklist, is provided to the auditor. This will give the provider the best chance of success, meaning the claim would actually be paid. Denied claims in a prepayment review can be appealed, and high denial rates may lead to more prepayment reviews, which can hurt cash flow for a provider. The post-payment audit process is outlined on this slide, and essentially the provider receives a letter from one of Medicare's auditors, the MAC or ZPIC, requesting records. The provider has typically about 45 days or 30 days in the case of a ZPIC to provide documentation. If the provider doesn't provide any documentation, there will be an automatic denial, and overpayments will be found for all the claims associated with that record. The auditors have between 30 and 60 days to make a determination as to whether the provider's payments were supported after reviewing the documentation notification sent by the provider. If there are any overpayments found, the provider will receive a demand letter, and that will trigger the provider's appeal rights to get that process started. This slide outlines the targeted probe and educate process, which is the most recent iteration of the Medicare claims audit program. In targeted probe and educate, MACs are targeting providers who have high claim error rates or unusual billing practices, and they're targeting items and services that have high national error rates that are deemed to be a financial risk to Medicare. So the targeted probe and educate audit process, which is what we're currently under, MACs are using data mining to identify either specific providers who are outliers or specific items and services that are high risk of improper billing to audit. These are typically done as prepayment reviews, and the MAC will review 20 to 40 claims and the supporting medical records for those claims. If there are denials, the MAC will invite the provider to a one-on-one education session on the reasons for the denial, and the provider is given a 45-day period to make changes and improve. This can go through several rounds. So most cases, according to CMS, providers that have gone through one round of targeted probe and educate have improved the accuracy of their claims and gotten off of this prepayment review. But some providers continue to have documentation errors even after the education sessions. And any problems that fail to improve after 3 rounds of education sessions will be referred to CMS for next steps. That may include 100% prepayment review on all of a provider's claims, extrapolation of overpayment amounts to a broader universe of claims, or referral to another auditor for more focused auditing. Okay, so that covers audits of a current Medicare provider's payment is one of CMS's. The next tool CMS has, and actually comes before the provider even has a chance to bill Medicare, is the provider enrollment process. Before you even get to the point where you have a provider number and billing privileges, you need to go through the Medicare provider enrollment process by submitting a CMS 855 form. This is the step where CMS can keep bad actors out of the Medicare program and potentially take away a provider's right to bill the program due to certain actions or inactions on that provider. This administrative tool is a move from CMS's pay and chase model, which was the traditional auditing theory, is to just review past claims that had already been paid, to more of a preventative enforcement model, which is in line with the prepayment reviews that are being done, and it flows through provider enrollment to actually keep potential bad actors out of the Medicare program. The first major roadblock CMS can put in place is to deny prospective Medicare providers' enrollment application. This prevents the provider from gaining a provider number in order to bill Medicare. Some of the reasons, and there are more outlined in the regulation that's cited on the slide, are outlined here, including noncompliance with enrollment requirements for the applicable provider type. For example, independent diagnostic testing facilities have very specific standards they must meet to enroll in the Medicare program. Not meeting one of those standards can lead to a denial of the enrollment application. Exclusion and debarment. If provider, an owner, managing employee, medical director, or other healthcare professional that's listed on the enrollment application is on the OIG's exclusion list or debarred by another agency from participating in federal healthcare programs, that can be another reason for denial of providers' application. Felonies can lead to denial of enrollment application. They would be felonies within the past 10 years and can include things like murder, rape, assault, extortion, embezzlement, income tax evasion, and other felonies that would cause mandatory exclusion from federal healthcare programs under the OIG's authority. That would include healthcare fraud. Falsifying any information on the enrollment application can lead to denial. And failing an on-site review, where CMS's contractor sends out not a surveyor, but a site visitor to essentially verify that the address is correct and the provider is operational. If the provider site visitor comes out and either can't find the provider because the address was not noted properly, or finds that the provider is not actually operational, that can lead to a denial of the enrollment application. Unresolved Medicare debt is another reason for denial, and that can include having an owner of the enrolling provider who was the owner of another provider or supplier that has an unresolved Medicare debt, and that other provider supplier had their enrollment either voluntarily terminated or revoked by CMS. So someone who owns a healthcare provider or supplier sort of can't get away from a Medicare debt by terminating that provider and trying to enroll as a new company. CMS has information through the enrollment process, Social Security numbers, dates of birth, on anyone who's an owner, that they can link to new applicants to tie them to old providers. If those providers have Medicare debts or are excluded in any way, that can lead to a denial. Finally, if the provider is under a payment suspension, any new enrollment applications may be denied. For a provider that is already enrolled and billing the Medicare program, there are certain actions or inactions that can lead to CMS revoking privileges and therefore its right to bill the Medicare program. Many of the reasons outlined in 42 CFR 424-535 are the same as the reasons for denial of an initial enrollment application. But there are some additional reasons for revocation as well. First, misuse of provider billing number. Allowing another individual or entity to use the provider's billing number unless they have a valid reassignment or have undergone the change of ownership process. Abuse of billing privileges can also lead to revocation of enrollment privileges. This means submitting claims that couldn't be furnished because, for instance, the beneficiary was dead or out of the country, or CMS determines that the provider or supplier has a pattern or practice submitting claims that fail to meet Medicare requirements. So this can come from audits that have been done over years, and as part of the Targeted Probe and Educate program, if the results of that, if the provider does not improve and continues to submit claims that don't meet Medicare requirements, CMS would have authority to revoke their enrollment and preclude them from billing Medicare in the future. So while Medicare denials are common and sort of an everyday occurrence for most medical practices and healthcare providers, a pattern of denials where the same issue comes up and is not fixed by the provider, that can lead to revocation. CMS determines that it's a pattern or practice. Failing to report changes of information on a provider's enrollment application can also lead to revocation. So these are things like address changes, name changes, ownership changes, managing employee changes, any of those pieces of information that have to be reported on the enrollment application. If they change, there's a corresponding regulation that sets time periods, either 30 or 90 days, for that information to be updated. If the provider fails to update their enrollment information and the MAC finds out about it, they can lead to revocation. Finally, specifically for physicians, improper prescribing practices or prescribing drugs for indications that are not medically accepted or not approved by the FDA can lead to revocation as well. once a provider's billing privileges have been revoked, there's typically a re-enrollment bar of 1 to 3 years. There is an appeal process that applies to enrollment revocations and also applies to denials of enrollment applications, but providers are not often successful in those appeals. CMS has broad discretion to enforce these regulations regarding denial and revocation, and typically the ALJs, the administrative law judges in those appeals, defer to CMS's discretion and find that CMS had the authority to take the enrollment action that it did. In sum, you do not want to have Medicare billing privileges revoked, especially Medicare is a large payer source for your organization. Getting those billing privileges back is often very difficult, if not impossible, and you have to wait out the re-enrollment bar of 1 to 3 years before re-enrolling in the Medicare program and being able to Medicare again. Finally, the last kind of tool in CMS's tool chest to bring enforcement actions on a Medicare provider's payment is payment suspension. This means shutting down some or all of a Medicare provider's cash flow while the investigation is conducted. Upon receiving notice of a payment suspension, a provider can continue to provide services to Medicare beneficiaries and submit claims to Medicare, but those claims will not be paid during the payment suspension. It will result in the accumulation of reimbursement due to the provider for approved claims in an escrow account. CMS has 2 sources of authority to impose a payment suspension on a Medicare provider. The first is that reliable information that an overpayment exists. This may be through the Medicare administrative contractor doing an audit or another auditor making an overpayment finding. The second source of authority is upon a credible allegation of fraud in consultation with the OIG. This was added by the Affordable Care Act, and sources of credible allegation of fraud can come from anywhere. It can come from a fraud hotline tip, data mining done by the OIG, DOJ, or their investigatory body, provider audits, or other law enforcement investigations. If the payment suspension is based on the Medicare contractor finding that there is reliable information that an overpayment exists, there is a notice requirement that the Medicare contractor give prior notice intent to suspend payments and the reasons for making the suspension. If the reason is a credible allegation of fraud, CMS consults with the OIG and they can determine not to give prior notice to the provider if in the best interest of the Medicare trust fund. There is a rebuttal process for payment suspensions, and it's an opportunity for the provider. Typically, it has to be at least 15 days given to the provider to submit a rebuttal. And this is an opportunity for the provider to make the case that there is good cause not to suspend this payment suspension, and there are several reasons for good cause outlined in the regulations at 405-371. A few of those reasons for good cause to not suspend payments include determination that beneficiary access to items or services would be so jeopardized by the payment suspension as to cause danger to life or health. It's a pretty high standard to meet. There's also a good cause when there's a determination that there are other more effective remedies. It may be something that the provider offers to CMS as to other remedies that they would agree to rather than have a payment suspension. Or there's a kind of a catch-all for CMS to make a determination that a payment suspension is not in the best interest of the Medicare program. Payment suspensions last for 6 months at a time and can last for up to 18 months with an extension, with an extension being approved. Importantly, you cannot appeal CMS's decision to impose a payment suspension, but you can appeal individual overpayment determination in the hopes of ending the suspension. So a payment suspension can be fatal to a provider's cash flow, especially if they rely on Medicare as a primary payer for most of their patients. And payment suspensions in conjunction with enrollment revocations are just some of the administrative tools CMS has to bring enforcement actions on providers that don't necessarily involve a False Claims Act case or OIG investigation. At this time, we've completed our presentation and welcome any comments. You can type them into the chat box on your screen.
Well, if we don't have any questions or comments, you can always, our contact information is on the screen as well. We thank you for being with us today, and please feel free to reach out to us to discuss any of these matters or anything regarding healthcare fraud or enforcement.
Thank you.